Question 1. The control framework reveals that creditor, holding a promissory note on which a surety is secondarily liable, enters into a written agreement with the principal debtor to forbear from suing the principal debtor for a period of 6 months without obtaining the surety's consent. Under the Uniform Commercial Code, UC, provisions governing negotiable instruments and suretyship. What is the most accurate legal impact of this agreement on the surety's obligation? Option A. The surety is discharged from their obligation on the note. Option B. The surety remains fully liable as the agreement only impacts the creditor's rights against the principal. Option C. The surety's liability is reduced by half due to the 6-month forbearance. Option D. The surety's obligation is unaffected because the principal debtor has not defaulted. The correct answer is A. The surety is discharged from their obligation on the note. Explanation. This scenario is professionally challenging because it requires a nuanced understanding of the UCC's provisions regarding the rights and obligations of parties involved in a suretyship agreement, specifically concerning the discharge of a surety. Misinterpreting these provisions can lead to significant financial and legal repercussions for the surety, the creditor, and the principal debtor. Careful judgment is required to apply the correct UCC sections to the specific facts presented. The correct approach involves recognizing that UCC Section 3-605(e) provides that a person secondarily liable on an instrument, which includes a surety, is discharged if the holder agrees not to sue the principal debtor. This agreement not to sue without the surety's consent materially alters the surety's risk by removing a primary avenue for recourse and potentially extending the time for payment or performance. Therefore, the surety is discharged from their obligation. This aligns with the fundamental principles of suretyship, where the surety's liability is typically coextensive with the principal debtor's, and any material alteration to the underlying obligation or the creditor's rights against the principal, without the surety's consent, can lead to discharge. An incorrect approach would be to assume that the agreement not to sue the principal debtor has no impact on the surety's obligation. This fails to acknowledge the specific protections afforded to sureties under UCC Section 3-605(e), which explicitly addresses the discharge of secondary obligors in such circumstances. This approach ignores the legal framework designed to prevent creditors from unilaterally altering the risk profile of a surety. Another incorrect approach would be to argue that the surety remains liable because the principal debtor has not defaulted on the original terms of the note. This overlooks the fact that the creditor's agreement not to sue the principal debtor is itself a modification of the creditor's rights that can prejudice the surety, regardless of the principal's current performance. The UCC provisions are concerned with the potential for prejudice, not just actual prejudice at the moment of the creditor's action. A further incorrect approach would be to assert that the surety's obligation is absolute and unaffected by any agreements between the creditor and the principal debtor. This fundamentally misunderstands the nature of suretyship and the specific discharge provisions within the UCC. Suretyship is not an absolute guarantee devoid of conditions. Rather, it is a contractual relationship with specific legal protections for the surety, including those outlined in UCC Section 3-605. The professional reasoning process for similar situations should involve 1. Identifying the nature of the relationship, e.g., suretyship. 2. Pinpointing the specific actions taken by the creditor concerning the principal debtor. 3. Consulting the relevant provisions of the UCC, particularly Article 3 concerning negotiable instruments and secondary liability. 4. Analyzing whether these actions constitute a modification or impairment of the creditor's rights against the principal debtor that, under the UCC, would discharge the surety. 5. Considering whether the surety consented to such modifications. Question 2. The performance metrics show a significant increase in claims filed against official bonds issued for public infrastructure projects, with a particular focus on a recent large-scale road construction project, where the obligee has submitted a claim alleging substantial delays and cost overruns due to the principal's alleged mismanagement. As the surety underwriter responsible for this bond, what is the most appropriate course of action to manage this claim effectively and compliantly? Option A. Advise the obligee to pursue legal action directly against the principal, disclaiming any immediate responsibility for the claim. Option B. Immediately initiate a thorough investigation into the principal's performance and the validity of the obligee's claim, reviewing all contractual documents and evidence of default before making any payment or denial. Option C. Pay the full amount of the claim as submitted by the obligee without further investigation to maintain a positive relationship with the obligee. Option D. Deny the claim outright to avoid immediate financial outlay, citing general concerns about project complexity and potential for unforeseen issues. The correct answer is B. Immediately initiate a thorough investigation into the principal's performance and the validity of the obligee's claim, reviewing all contractual documents and evidence of default before making any payment or denial. Explanation: this scenario is professionally challenging because it requires a surety underwriter to balance the immediate financial implications of a claim against the long-term reputational and regulatory standing of the surety company. The underwriter must navigate the complex interplay between contractual obligations, the specific terms of the official bond, and the relevant regulatory framework governing public works projects and surety operations. A hasty decision could lead to significant financial loss, regulatory penalties, or damage to the surety's ability to secure future business. The correct approach involves a thorough investigation of the claim's validity and the principal's performance, followed by a decision that aligns with the surety's contractual obligations and regulatory duties. This approach prioritizes adherence to the terms of the official bond, which is a contract of indemnity, and ensures compliance with the principles of suretyship. Specifically, it requires the surety to assess whether the principal has indeed defaulted on their obligations, as defined by the bond and the underlying contract. If a default is established, the surety must then determine the extent of its liability and the most appropriate course of action, which may include indemnification of the obligee, seeking recourse from the principal, or negotiating a resolution. This methodical process safeguards the surety's financial interests while upholding its commitment to the obligee and adhering to regulatory expectations for prompt and fair claim handling. An incorrect approach that focuses solely on the immediate cost savings by denying the claim without a comprehensive investigation is professionally unacceptable. This failure stems from a disregard for the contractual commitment inherent in the official bond. The surety has a legal and ethical obligation to the obligee, and arbitrarily denying a claim without due diligence breaches this trust and violates the principles of suretyship. Such an action could expose the surety to legal action for breach of contract and potentially lead to regulatory sanctions for unfair claim settlement practices. Another incorrect approach that involves immediately paying the full claim amount without verifying the extent of the principal's default or exploring mitigation options is also professionally unsound. While this might appear to be a swift resolution, it fails to protect the surety's interests and potentially overcompensates the obligee. The surety's obligation is to cover the loss resulting from the principal's default, not to provide a windfall. This approach neglects the surety's right to seek recovery from the principal and may violate internal risk management policies and regulatory guidelines that encourage prudent financial management and loss mitigation. A professional decision-making process for similar situations should involve a structured approach. 1. Acknowledge and document the claim promptly. 2. Conduct a comprehensive investigation into the alleged default, reviewing all relevant documentation, including the bond, underlying contract, project specifications, and evidence of non-performance. 3. Assess the principal's performance and the validity of the obligee's claim against the terms of the bond and applicable laws. 4. Consult with legal counsel if the claim is complex or involves significant financial exposure. 5. Communicate effectively with all parties involved, including the obligee and the principal. 6. Make a decision based on the findings of the investigation and the surety's contractual and regulatory obligations, aiming for a fair and equitable resolution that minimizes loss for all parties while upholding the integrity of the surety's commitments. Question 3. The performance metrics show a significant increase in the time taken to underwrite and issue performance bonds, impacting client satisfaction and internal efficiency. Considering the principles of suretyship exam's regulatory framework, which approach to optimizing this process is most aligned with ensuring continued compliance and sound risk management. Option A. Focus solely on reducing the turnaround time for performance bond issuance by prioritizing speed over the thoroughness of the principal's financial and contractual risk assessment. Option B. Implement a new digital platform that automates the initial data capture and preliminary risk scoring for all performance bond applications, flagging only those that fall outside predefined Regulatorily compliant risk parameters for manual review by experienced underwriters. Option C. Reduce the required documentation for performance bond applications below the minimum threshold stipulated by industry regulations to expedite the submission and review process. Option D. Delegate the final approval authority for all performance bonds, regardless of value or complexity, to junior underwriting staff to increase throughput. The correct answer is B. Implement a new digital platform that automates the initial data capture and preliminary risk scoring for all performance bond applications, flagging only those that fall outside predefined, regulatorily compliant risk parameters for manual review by experienced underwriters. Explanation: this scenario is professionally challenging because it requires a surety underwriter to balance the need for efficient process optimization with the absolute priority of adhering to regulatory frameworks designed to protect all parties involved in suretyship. The core tension lies in streamlining operations without compromising the integrity of risk assessment and the legal enforceability of performance bonds. Careful judgment is required to ensure that any process improvements do not inadvertently weaken the surety's position or violate the principles of suretyship as defined by the relevant regulatory body. The correct approach involves a thorough review of the existing performance bond underwriting process to identify bottlenecks and inefficiencies, followed by the implementation of targeted compliant solutions. This approach is right because it prioritizes regulatory adherence and sound underwriting principles. Specifically, it ensures that any optimization does not bypass essential due diligence steps, such as verifying the principal's capacity, the contract's terms, and the obligee's requirements, all of which are critical for assessing risk and ensuring the performance bond's validity under the governing laws and regulations. This proactive and compliant method upholds the surety's fiduciary duty and maintains market confidence. An incorrect approach that focuses solely on speed without considering regulatory implications would be to automate the approval of performance bonds for certain contract values without sufficient independent verification of the principal's financial stability or the contract's risk profile. This fails to meet the regulatory requirement for prudent underwriting and could expose the surety to unacceptable risks, potentially leading to financial losses and regulatory sanctions. Another incorrect approach would be to reduce the level of detail required in the performance bond application and supporting documentation to expedite processing. This violates the principle of thorough risk assessment, which is a cornerstone of suretyship regulation. Omitting critical information can render the bond unenforceable or lead to underpricing of risk, both of which are regulatory failures. Finally, an approach that delegates the final underwriting decision for performance bonds to less experienced personnel without adequate oversight or training in the name of efficiency is also incorrect. This disregards the regulatory expectation of competent and experienced decision-making in the surety industry, increasing the likelihood of errors and noncompliance. Professionals should employ a decision-making framework that begins with a clear understanding of the applicable regulatory framework and its underlying principles. This framework should then guide the evaluation of any proposed process changes, ensuring that efficiency gains do not come at the expense of compliance, risk management, or ethical conduct. Continuous training and a culture of regulatory awareness are essential to navigate these challenges effectively. Question 4. Stakeholder feedback indicates that there is confusion regarding the enforceability of suretyship agreements when the principal debtor is already in default. A bank provides a loan to a business. The business subsequently defaults on its loan obligations. The owner's sibling, wanting to prevent the bank from immediately seizing business assets, signs a written guarantee for the outstanding loan amount. The bank, in reliance on this guarantee, refrains from initiating immediate legal proceedings to recover the debt for a period of 3 months, during which time the business attempts to restructure its finances. After 3 months, the business still cannot repay the loan, and the bank seeks to enforce the guarantee against the sibling. What is the most legally sound basis for enforcing the guarantee? Option A. The sibling's guarantee is enforceable due to the familial relationship between the sibling and the business owner. Option B. Sibling's guarantee is enforceable because the bank's forbearance from immediate legal action constitutes valid consideration for the sibling's promise. Option C. The sibling's guarantee is unenforceable because the principal debtor was already in default, meaning the bank had no new rights to extend. Option D. The siblings' guarantee is enforceable because the bank continued to allow the business to operate without immediate legal action. The correct answer is B. The siblings' guarantee is enforceable because the bank's forbearance from immediate legal action constitutes valid consideration for the siblings' promise. Explanation: this scenario is professionally challenging because it requires a nuanced understanding of consideration within suretyship agreements, specifically distinguishing between pre-existing duties and new value. The core difficulty lies in determining whether the surety's promise is supported by legally sufficient consideration, which is a fundamental requirement for contract enforceability under general contract law principles, as applied to suretyship. Misinterpreting consideration can lead to unenforceable agreements, financial losses, and reputational damage. The correct approach involves recognizing that the bank's forbearance from immediate legal action against the principal debtor, in exchange for the surety's guarantee, constitutes valid consideration. This is because the bank is giving up a legal right, the right to sue immediately, which it otherwise possessed. This forbearance is a detriment to the bank and a benefit to the principal debtor, and indirectly to the surety by delaying the need for the surety to pay. This exchange of value, where one party does something they are not legally obligated to do or refrains from doing something they have a legal right to do, is a recognized form of consideration. This aligns with established principles of contract law that underpin suretyship agreements, ensuring that the surety's promise is not gratuitous and is legally binding. An incorrect approach would be to argue that the surety's promise is unenforceable because the principal debtor was already obligated to repay the loan. This fails to recognize that the surety's promise is a separate undertaking, and the consideration for that promise comes from the obligee, the bank, not the principal debtor. The bank's action or forbearance is the bargain for exchange for the surety's guarantee. Another incorrect approach would be to assert that the bank's continued extension of credit to the principal debtor, without more, is sufficient consideration. While continued credit can be consideration, in this specific scenario, the bank's forbearance from immediate legal action is the more direct and legally recognized consideration for the surety's guarantee. Simply continuing to allow the principal debtor to operate without immediate legal recourse is not necessarily a new benefit conferred upon the surety or a detriment to the bank in the same way as foregoing a specific legal right. Finally, assuming the surety's promise is automatically binding due to the familial relationship with the principal debtor would be an incorrect approach. Familial ties do not substitute for legal consideration in contract law. Professional decision-making in such situations requires a systematic analysis of the agreement's terms, identifying the promises made by each party, and critically evaluating whether there has been a legally sufficient exchange of value, consideration, for the surety's undertaking. This involves understanding the distinction between a promise supported by consideration and a gratuitous promise, and applying established legal principles to the specific facts of the case. Question 5. Operational review demonstrates that a surety, having discharged the full obligation of a principal debtor, now seeks to recover the excess amount paid from their co-sureties. The principal debtor is demonstrably insolvent, and one of the co-sureties is also experiencing significant financial distress. Which of the following best describes the appropriate course of action for the surety who has paid the full obligation to recover their proportionate share from the other co-sureties? Option A. The surety who paid the full obligation should wait for a formal demand from the original creditor before pursuing any action against the co-sureties. Option B. The surety who paid the full obligation should initiate legal proceedings to recover the excess amount paid from the remaining solvent co-sureties, based on their proportionate liability, regardless of the principal debtor's insolvency. Option C. The surety who paid the full obligation should seek to recover the entire amount paid from the co-surety who is experiencing financial distress, as they are the only remaining viable option for recovery. Option D. The surety who paid the full obligation should abandon their claim for contribution as the principal debtor is insolvent, making recovery from other co-sureties impractical. Correct answer is B. The surety who paid the full obligation should initiate legal proceedings to recover the excess amount paid from the remaining solvent co-sureties, based on their proportionate liability, regardless of the principal debtor's insolvency. Explanation: this scenario presents a professional challenge because it requires understanding the nuances of the right of contribution among co-sureties, particularly when one surety has paid more than their proportionate share of the principal's debt. The challenge lies in correctly identifying the legal basis for seeking contribution and the procedural steps involved, ensuring compliance with the relevant regulatory framework governing suretyship principles. A thorough understanding of the underlying legal principles is crucial to avoid potential disputes and ensure equitable distribution of the burden among co-sureties. The correct approach involves the surety who has paid in excess of their share, initiating a claim for contribution against the other co-sureties. This is based on the equitable principle that, where two or more persons are bound by the same obligation, and one discharges more than their fair proportion of the common burden, they are entitled to recover the excess from the others. This right arises from the moment the co-surety pays the debt, even if the principal debtor has defaulted. The regulatory framework for the Principles of Suretyship exam would typically support this by outlining the rights and obligations of sureties, including the right to contribution, which is a fundamental aspect of suretyship law. An incorrect approach would be to assume that the right of contribution is automatically extinguished if the principal debtor is insolvent, or if the other co-sureties are also facing financial difficulties. While the practical recovery might be affected by the financial standing of the co-sureties, the legal right to contribution itself remains. Another incorrect approach would be to wait for a formal demand from the principal debtor or a creditor before seeking contribution. The right of contribution arises from the payment made by one surety, not from a demand for payment from the principal or creditor. Furthermore, attempting to recover the full amount paid from only one of the other co-sureties, without considering the proportionate liability of all co-sureties, would be an incorrect approach, as it fails to adhere to the principle of equitable distribution. Professionals should approach such situations by first identifying all co-sureties and their respective liabilities. They should then ascertain the total amount paid by the surety seeking contribution and compare it to their proportionate share of the debt. If an excess has been paid, the next step is to formally notify the other co-sureties of their liability for contribution, providing evidence of the payment made and the basis for the claim. This process should be guided by the principles of suretyship law and any specific contractual agreements between the sureties. Question 6. Market research demonstrates that a significant number of commercial disputes arise from the interpretation of suretyship agreements. A surety has provided a guarantee for a loan to a company. The loan agreement contains a clause stating the company shall repay the loan in full. The suretyship agreement states the surety guarantees the performance of the company's obligations under the loan agreement. The company defaults on the loan, and the creditor seeks to recover the full outstanding amount from the surety. The surety argues their liability is limited to the principal amount of the loan, excluding accrued interest and fees. Based solely on UK regulatory framework and common law principles of contract interpretation, what is the most appropriate approach for determining the surety's liability? Option A. Interpret the suretyship agreement by examining the precise wording of the guarantee and the underlying loan agreement, applying common law principles of contract interpretation to ascertain the parties' intent regarding the scope of the surety's obligations, including all amounts due under the loan. Option B. Assume the surety's liability is limited to the principal amount of the loan, as this is the core obligation being guaranteed, and any additional amounts like interest and fees are secondary. Option C. Rely on general industry understanding of suretyship, which often implies a limit on surety liability to the principal debt unless explicitly stated otherwise. Option D. Interpret the agreement based on the creditor's reasonable expectations of recovery, assuming the surety intended to cover all potential financial losses arising from the default. The correct answer is A. Interpret the suretyship agreement by examining the precise wording of the guarantee and the underlying loan agreement, applying common law principles of contract interpretation to ascertain the parties' intent regarding the scope of the surety's obligations, including all amounts due under the loan. Explanation. This scenario presents a professional challenge because the interpretation of a suretyship agreement hinges on understanding the precise language used and the legal principles governing such contracts within the specified jurisdiction. Ambiguity in the agreement can lead to significant financial exposure for the surety and potential disputes with the creditor or principal. Careful judgment is required to avoid misinterpreting the scope of the surety's obligations, which could result in unintended liabilities. The correct approach involves a meticulous examination of the suretyship agreement's wording, considering established legal doctrines for contract interpretation. This includes looking for express terms, implied terms, and the overall intent of the parties at the time the agreement was made. Within the UK regulatory framework, the Unfair Contract Terms Act 1977 UCTA and the Consumer Rights Act 2015 CRA are relevant if the surety is acting in a consumer capacity or if the terms are deemed unfair. However, for commercial suretyships, common law principles of contract interpretation, such as the contra pro frentem rule, interpreting ambiguous terms against the party who drafted them, and the principle of giving commercial efficacy to the contract, are paramount. The focus should be on the plain meaning of the words used, unless there is clear evidence of a contrary intention or a specific legal provision dictates otherwise. An incorrect approach would be to assume the surety's liability is unlimited simply because they are a surety. This ignores the principle that a surety's obligation is typically coextensive with that of the principal debtor, but not necessarily broader, and is subject to the specific terms of the suretyship agreement. Relying solely on the fact that a guarantee was provided without scrutinizing its precise scope is a failure to exercise due diligence. Another incorrect approach would be to interpret the agreement based on industry custom or practice without clear evidence that such custom was intended to be incorporated into the specific agreement. While custom can sometimes inform interpretation, it cannot override express contractual terms. Furthermore, assuming that the creditor's expectations, rather than the explicit terms of the agreement, define the surety's liability is a significant legal and ethical failure. The creditor's expectations must be grounded in the contractual obligations undertaken by the surety. A further incorrect approach would be to apply a broad, general understanding of suretyship without reference to the specific wording of the agreement and relevant UK case law on contract interpretation. This overlooks the fact that suretyship agreements are contracts, and their interpretation is governed by established principles of contract law, which emphasize the literal meaning of the words used and the intention of the parties as expressed in the document. The professional decision-making process for similar situations should involve 1. Thoroughly reviewing the suretyship agreement, identifying all relevant clauses and definitions. 2. Researching applicable UK legislation and relevant case law concerning contract interpretation and suretyship. 3. Analyzing the language of the agreement for any ambiguities or potential for misinterpretation. 4. Considering the context in which the agreement was made and the presumed intentions of the parties. 5. Applying established legal principles of contract interpretation to resolve any ambiguities, prioritizing the express terms of the agreement. 6. Consulting with legal counsel if significant interpretative challenges arise. Question 7. Process analysis reveals that a principal debtor has defaulted on a significant loan, and the creditor has initiated proceedings to recover the outstanding balance. 3 co-sureties, A, B, and C, had each provided separate suretyship agreements for this loan. Co-surety A's guarantee was for £50,000, co-surety B's for £75,000, and co-surety C's for £100,000. The total outstanding loan amount is £150,000. Co-surety B has recently become insolvent and is unable to contribute any funds. Co-surety has already paid £20,000 towards the debt. Which approach best reflects the legal and ethical obligations of co-surety C in this situation? Assuming the governing jurisdiction is the United Kingdom and adheres to principles of suretyship law as commonly understood within that framework. Option A. Co-surety C should refuse to pay anything until the creditor has exhausted all legal avenues to recover from co-surety and the insolvent estate of co-surety B. Option B. Co-surety C should pay the entire remaining balance of the loan to the creditor, as co-surety B is insolvent and co-surety has already made a partial payment. Option C. Co-surety C should pay an equal share of the remaining debt with co-surety A, as they are the only two solvent co-sureties. Option D. Co-surety C should pay a proportionate share of the remaining debt based on the original value of their guarantee relative to the total value of the solvent co-surety's guarantees, after accounting for co-surety A's prior payment. The correct answer is B. Co-surety C should pay the entire remaining balance of the loan to the creditor, as co-surety B is insolvent and co-surety has already made a partial payment. Explanation: this scenario is professionally challenging because it involves multiple parties with potentially competing interests and differing levels of understanding regarding their obligations. The core difficulty lies in ensuring equitable treatment and adherence to legal principles when a surety defaults, and the remaining co-sureties must step in. The requirement for careful judgment stems from the need to balance the rights of the creditor with the proportionate liabilities of the co-sureties, all within the strict confines of the governing suretyship laws. The correct approach involves the remaining co-sureties contributing to the creditor's loss in proportion to their respective guarantees, after accounting for any payments already made by the defaulting surety or any other co-sureties. This aligns with the principle of proportionate liability, which is fundamental to co-suretyship. Each co-surety is generally liable for a share of the debt, not necessarily an equal share, unless their guarantees were identical in amount and terms. The law typically aims to prevent unjust enrichment of the creditor and to ensure that no single co-surety bears an undue burden beyond their agreed-upon risk. This approach is ethically sound as it upholds fairness and contractual integrity. An incorrect approach would be for the remaining co-sureties to refuse to contribute until the defaulting surety's estate has been fully exhausted, regardless of the creditor's immediate need for payment. This fails to acknowledge the creditor's right to seek satisfaction from any available surety. Another incorrect approach would be for the remaining co-sureties to divide the remaining liability equally, irrespective of the original amounts of their respective guarantees. This disregards the principle of proportionate liability and could unfairly burden a co-surety who originally assumed a lesser risk. A further incorrect approach would be for one co-surety to unilaterally pay the entire outstanding debt and then attempt to recover the full amount from the other co-sureties, rather than coordinating a proportionate contribution. This bypasses the established legal framework for co-surety contributions and could lead to disputes and inefficiencies. Professionals should approach such situations by first thoroughly understanding the terms of each suretyship agreement and the total amount of the debt. They must then ascertain the extent of the defaulting surety's contribution, if any, and the remaining balance owed to the creditor. The next step is to calculate each solvent co-surety's proportionate share of the remaining liability based on the original terms of their guarantees. Open communication with the creditor and the other co-sureties is crucial to facilitate a timely and equitable resolution. This decision-making process prioritizes legal compliance, fairness, and efficient resolution of the surety obligation. Question 8. The monitoring system demonstrates that creditor, relying on an oral assurance from a business owner that they would make sure the supplier gets paid for goods delivered to a related company, has extended credit. The business owner has now refused to pay when the related company defaulted. The creditor is seeking to enforce the business owner's assurance. Which of the following actions best reflects the legally sound approach to this situation? Considering the principles of suretyship enforceability. Option A. Suggest that the creditor focus on the existing business relationship between the parties as grounds for enforcing the oral assurance, implying a mutual understanding of responsibility. Option B. Pursue legal action to enforce the oral assurance, arguing that the business owner's intent to ensure payment creates a binding obligation. Option C. Advise the creditor that, absent a written and signed agreement by the business owner to guarantee the debt of the related company, the oral assurance is generally not enforceable as a suretyship agreement under the statute of frauds. Option D. Recommend that the creditor attempt to obtain a written confirmation of the oral assurance from the business owner after the default, as this may retroactively validate the agreement. The correct answer is B. Pursue legal action to enforce the oral assurance, arguing that the business owner's intent to ensure payment creates a binding obligation. Explanation. The monitoring system demonstrates a common implementation challenge in suretyship, ensuring enforceability of guarantees. The core issue revolves around the statute of frauds, which, in most jurisdictions governing suretyship, requires a promise to answer for the debt of another, a suretyship agreement, to be in writing and signed by the party to be charged, the surety, to be enforceable. This requirement is a critical safeguard against fraudulent claims and ensures clarity regarding the surety's obligations. The professionally challenging aspect of this scenario lies in distinguishing between a legally binding suretyship agreement and a mere oral promise or collateral undertaking that may not meet the statutory writing requirement. Misinterpreting the enforceability of an oral guarantee can lead to significant financial losses for the surety, disputes with creditors, and potential reputational damage. It requires careful consideration of the specific language used, the intent of the parties, and the precise nature of the undertaking. The correct approach involves a thorough review of the communication to determine if it constitutes a promise to answer for the debt of another that satisfies the statute of frauds. This means assessing whether the promise was made in writing and signed by the surety. If the communication is purely oral, or if it lacks the surety's signature, it is generally not enforceable as a suretyship agreement under the statute of frauds. Focus should be on objective evidence of a written and signed undertaking. An incorrect approach would be to rely solely on the creditor's belief that a guarantee was given, or on the existence of a business relationship, as sufficient evidence of enforceability. The statute of frauds is a legal bar to enforcing oral suretyship agreements, regardless of the party's intentions or the creditor's expectations. Another incorrect approach is to assume that any mention of a third party's debt in a communication implies a legally binding guarantee. The language must clearly indicate an undertaking to be personally liable for that debt. Professionals should adopt a decision-making process that prioritizes adherence to the statute of frauds. This involves 1. Identifying whether the communication constitutes a promise to answer for the debt of another. 2. If so, determining if the promise is in writing and signed by the surety. 3. If either of these conditions is not met, recognizing that the agreement is likely unenforceable as a suretyship. 4. Seeking legal counsel when in doubt about the interpretation of communications and their enforceability under suretyship laws. Question 9. System analysis indicates that a surety has received a claim on a performance bond. During the investigation of this claim, evidence emerges suggesting that the obligee, prior to the execution of the suretyship agreement, made material misrepresentations regarding the principal's financial stability and the project's scope, which were relied upon by the surety in underwriting the bond. What is the most appropriate course of action for the surety in this situation? Option A. Immediately pay the claim in full to avoid further disputes and potential legal action from the obligee. Option B. Proceed with an immediate investigation into the alleged misrepresentations to determine their materiality and impact on the suretyship agreement, and consult legal counsel regarding potential defenses. Option C. Deny the claim outright based on the suspicion of misrepresentation without conducting a thorough investigation. Option D. Terminate the suretyship agreement unilaterally due to the alleged fraud, without establishing its materiality or impact. The correct answer is B. Proceed with an immediate investigation into the alleged misrepresentations to determine their materiality and impact on the suretyship agreement, and consult legal counsel regarding potential defenses. Explanation. This scenario presents a professionally challenging situation because it requires the surety to navigate the potential impact of the obligee's actions on the underlying suretyship agreement. The core challenge lies in determining whether the obligee's misrepresentation or fraud has fundamentally altered the surety's risk profile or discharged its obligations. Careful judgment is required to distinguish between minor inaccuracies and material misrepresentations that could vitiate the surety bond. The correct approach involves a thorough investigation into the nature and materiality of the alleged fraud or misrepresentation by the obligee. This includes gathering evidence to substantiate the claim and assessing whether the obligee's conduct directly induced the surety to enter into the suretyship agreement or significantly increased the surety's exposure beyond what was originally contemplated. If material fraud or misrepresentation is established, the surety may have grounds to seek avoidance of the suretyship contract, as this would likely contravene the principles of good faith and fair dealing inherent in suretyship law. This aligns with the regulatory framework that emphasizes the importance of accurate disclosure and prohibits fraudulent conduct by parties to a contract, including suretyship agreements. An incorrect approach would be to immediately pay out on the bond without investigating the fraud claim. This fails to uphold the surety's duty to protect its own interests and could lead to financial loss due to the obligee's misconduct. It also ignores the potential for the surety to seek relief from its obligations if the contract was entered into under fraudulent pretenses. Another incorrect approach would be to dismiss the fraud claim outright without proper investigation, assuming the obligee's representations were accurate. This demonstrates a lack of due diligence and could expose the surety to liability for a bond that was procured through deception. It disregards the ethical obligation to act with integrity and to address potential breaches of good faith. A further incorrect approach would be to unilaterally terminate the suretyship agreement based solely on the allegation of fraud, without establishing its materiality or impact. This could lead to a breach of contract claim by the obligee if the fraud is not proven to be material or if the surety's actions are deemed wrongful. The professional decision-making process for similar situations should involve a systematic approach. 1. Acknowledge and document the allegation of fraud or misrepresentation. 2. Initiate a prompt and thorough investigation to gather all relevant facts and evidence. 3. Assess the materiality of the alleged fraud or misrepresentation and its impact on the surety's risk and obligations. 4. Consult with legal counsel to understand the legal implications and available remedies under the applicable regulatory framework. 5. Communicate with all relevant parties, including the principal and the obligee, regarding the findings and proposed course of action. 6. Act in accordance with legal advice and regulatory requirements to protect the surety's interests while upholding ethical standards. Question 10. Benchmark analysis indicates that while the statute of frauds generally requires contracts of suretyship to be in writing, courts have recognized certain exceptions to prevent injustice. A business owner verbally promises a supplier that they will personally guarantee payment for goods to be supplied to a struggling subsidiary, stating, "If they don't pay, I'll make sure you get your money." The supplier, relying on this assurance, extends credit to the subsidiary. Subsequently, the subsidiary defaults, and the supplier seeks payment from the business owner. Which of the following approaches best reflects the likely legal outcome, considering potential exceptions to the writing requirement? Option A. The verbal guarantee is automatically enforceable because the supplier extended credit, regardless of the business owner's intent or the foreseeability of the supplier's reliance. Option B. The verbal guarantee is unenforceable because the supplier should have insisted on a written agreement, and the business owner's statement was merely a casual assurance. Option C. The verbal guarantee is unenforceable because it is a contract of suretyship and therefore must be in writing under the statute of frauds, with no exceptions applicable. Option D. The verbal guarantee may be enforceable if the business owner's primary motivation was their own economic benefit in ensuring the subsidiary's continued operation, thereby falling under the leading object exception. Correct answer is C. The verbal guarantee is unenforceable because it is a contract of suretyship and therefore must be in writing under the statute of frauds, with no exceptions applicable. Explanation. This scenario is professionally challenging because it requires a nuanced understanding of when the statute of frauds, which generally mandates that contracts of suretyship be in writing, can be circumvented by equitable exceptions. The core difficulty lies in distinguishing between a situation where a verbal promise is unenforceable due to the statute of frauds and one where equity intervenes to prevent injustice. Professionals must carefully assess the facts to determine if the elements of an equitable exception, such as detrimental reliance or the leading object rule, are present. The correct approach involves recognizing that while the general rule requires a written suretyship agreement, certain established exceptions exist to prevent fraudulent outcomes. In this case, if the surety's promise was primarily for their own economic benefit, the leading object rule, or if the promisee suffered significant and foreseeable detriment in reliance on the verbal promise, a court might enforce the agreement despite the lack of writing. This aligns with the principle that statutes designed to prevent fraud should not be used as instruments of fraud themselves. An incorrect approach would be to rigidly apply the statute of frauds without considering any potential equitable exceptions. This would lead to the surety escaping liability despite potentially inducing reliance or benefiting from the underlying transaction. Another incorrect approach would be to misapply an equitable exception. For instance, by asserting detrimental reliance when the reliance was not foreseeable or substantial enough to warrant an exception. A further incorrect approach would be to confuse a contract of suretyship with other types of contracts that may have different writing requirements or exceptions. Professional decision-making in such situations requires a thorough factual investigation, a deep understanding of the relevant statutory provisions and their judicially recognized exceptions, and an objective assessment of whether the circumstances meet the stringent criteria for invoking an equitable remedy. It involves balancing the legislative intent behind the statute of frauds with the equitable imperative to prevent unjust enrichment or unconscionable outcomes. Question 11. Compliance review shows that a financial services firm has entered into an agreement where it promises to perform a specific contractual obligation on behalf of a client if the client fails to do so, and the firm's liability is directly tied to the performance of that obligation, not merely to compensate for a loss arising from non-performance. Based on the principles of suretyship, exams focus on the UK regulatory framework. How should this undertaking be most accurately characterized for regulatory and risk management purposes? Option A, a collateral agreement. Option B, an indemnity. Option C, a guarantee. Option D, a suretyship. The correct answer is D, a suretyship. Explanation: scenario analysis. This scenario is professionally challenging because it requires a precise understanding of the legal distinctions between suretyship, guarantee, and indemnity, particularly as these concepts are defined and applied within the regulatory framework governing financial services in the UK, as relevant to the principles of suretyship exam. Mischaracterizing these relationships can lead to significant legal and financial liabilities for the firm and its clients, impacting contractual enforceability and regulatory compliance. The challenge lies in applying abstract legal definitions to a concrete business transaction and advising stakeholders accurately based on their specific roles and the nature of the undertaking. Correct approach analysis. The correct approach involves accurately identifying the undertaking as a suretyship. This is because a surety is primarily liable for the debt or obligation of another, and the surety's obligation is typically coextensive with that of the principal debtor. In the context of the principles of suretyship exam, which focuses on the UK regulatory framework, this means recognizing that the surety is not merely secondarily liable, but is directly bound to the creditor. This aligns with the core principles of suretyship, where the surety often undertakes the obligation as a primary obligor, even if the principal debtor is the one who directly owes the performance. The regulatory framework emphasizes the substance of the agreement over its form, and if the undertaking creates a primary liability for the firm, it must be treated as such. Incorrect approaches analysis. An approach that characterizes the undertaking as a guarantee would be incorrect because a guarantee, while related, typically involves a secondary liability. Guarantor promises to pay or perform if the principal debtor defaults. While often used interchangeably in common parlance, legally, a guarantee is distinct from a suretyship, with the surety often being seen as more directly bound. Misclassifying a suretyship as a guarantee could lead to an incorrect assessment of the firm's exposure and reporting obligations. An approach that classifies the undertaking as an indemnity would also be incorrect. An indemnity is a promise to keep another person harmless from loss. While an indemnity can sometimes resemble a guarantee or suretyship, it is fundamentally different. An indemnifier promises to reimburse for loss, whereas a surety or guarantor promises to perform the underlying obligation. In this scenario, if the firm is undertaking the obligation itself, rather than merely compensating for a loss arising from another's default, it is not an indemnity. This distinction is crucial for understanding the nature of the firm's liability and the conditions under which it would be triggered. Professional reasoning. Professionals should approach such situations by first meticulously examining the contractual terms and the substance of the undertaking. They must then cross-reference these terms with the definitions and legal principles of suretyship, guarantee, and indemnity as established within the relevant UK regulatory framework and common law. This involves considering who is primarily liable, the conditions under which liability arises, and the nature of the promise made. A stakeholder perspective is vital, ensuring that the advice provided clearly articulates the legal position and potential liabilities to all parties involved, enabling informed decision-making and robust risk management. Question 12. The risk matrix shows a potential claim arising from a principal's default on a construction project. The surety bond has a penal sum of $500,000. The obligee is claiming $600,000, which includes the cost to complete the remaining work, $450,000. Liquidated damages for project delay, $100,000, and the cost of hiring a consultant to oversee the completion, $50,000. The surety underwriter must determine the extent of the surety's liability. Which approach best reflects the evaluation of liability under the principles of suretyship exam framework? Option A. The surety is liable for the cost to complete the remaining work, $450,000, plus the liquidated damages, $100,000, totaling $550,000, as these are direct consequences of the principal's default. Option B. The surety is only liable for the cost to complete the remaining work, $450,000, as this is the direct cost of remedying the principal's failure to perform the core obligation. Option C. The surety's liability is limited to the actual damages proven by the obligee, up to the penal sum of $500,000, requiring a careful assessment of whether liquidated damages and consultant fees are recoverable under the bond and underlying contract. Option D. The surety is liable for the full $500,000 penal sum, as this is the maximum stated in the bond, regardless of the specific breakdown of the obligee's claimed damages. The correct answer is D. The surety is liable for the full $500,000 penal sum, as this is the maximum stated in the bond, regardless of the specific breakdown of the obligee's claimed damages. Explanation. This scenario presents a professional challenge because the surety underwriter must accurately assess the extent of their client's liability when a principal defaults on a bonded obligation. The core difficulty lies in interpreting the surety bond's terms and conditions in conjunction with the underlying contract and the principal's performance, all while adhering to the regulatory framework governing suretyship. A failure to correctly evaluate liability can lead to underpayment of claims, exposing the surety to financial loss or overpayment, impacting profitability. Professional judgment is crucial in distinguishing between direct liability for the principal's default and consequential damages or indirect losses that may not be covered. The correct approach involves a meticulous review of the surety bond's penal sum, the specific obligations undertaken by the principal, and any exclusions or limitations stipulated in the bond and the underlying contract. This approach prioritizes a thorough understanding of the surety's contractual undertaking. Regulatory frameworks, such as those governing the conduct of surety companies and the interpretation of surety contracts, mandate that the surety honor its obligations within the bond's limits. Ethical considerations also demand fair and prompt settlement of valid claims. This approach ensures compliance with the surety's contractual promises and regulatory duties. An incorrect approach would be to assume the penal sum of the bond is the absolute maximum liability without considering the specific nature of the default and the actual losses incurred by the obligee. This overlooks the principle that the surety's liability is typically limited to the actual damages suffered by the obligee, up to the penal sum. Another incorrect approach is to automatically deny any claim for damages beyond the direct cost of completing the principal's work, without considering other foreseeable and direct losses that may be covered by the bond's terms. This fails to acknowledge that a surety's liability can extend to certain consequential damages if they are a direct and proximate result of the principal's breach and are contemplated by the bond. A further incorrect approach is to rely solely on the principal's assurances regarding their financial position or the extent of the default, without independent verification and a thorough review of the obligee's claim documentation. This abdication of due diligence violates the duty of care owed by the surety and can lead to misjudgments about liability. Professional decision-making in such situations requires a systematic process. First, thoroughly understanding the surety bond and the underlying contract. Second, gathering all relevant documentation from the obligee and the principal. Third, analyzing the nature and extent of the principal's default. Fourth, quantifying the obligee's losses. And fifth, applying the terms of the bond and relevant legal principles to determine the surety's liability, always within the bounds of regulatory compliance and ethical conduct. Question 13. What factors determine whether a suretyship agreement remains enforceable when the underlying contract it secures is found to be illegal? Option A. The extent to which the illegality of the underlying contract fundamentally undermines its purpose, and whether the suretyship was entered into with knowledge of or participation in the illegal act. Option B. The duration of the suretyship agreement and the market conditions at the time of default. Option C. The financial standing of the guarantor and the creditor's desire to recover the debt. Option D. The presence of a signed suretyship document and the default of the principal debtor. The correct answer is A. The extent to which the illegality of the underlying contract fundamentally undermines its purpose, and whether the suretyship was entered into with knowledge of or participation in the illegal act. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a suretyship professional to assess the enforceability of a guarantee when the underlying contract it secures is tainted by illegality. The core difficulty lies in distinguishing between situations where the suretyship obligation is void ab initio due to the illegality, and those where the guarantor might still be liable, or where the illegality might be severable. This demands a nuanced understanding of contract law principles as they apply to suretyship, and a careful risk assessment to avoid potential professional negligence claims or reputational damage. Correct approach analysis. The correct approach involves a thorough examination of the nature and extent of the illegality in the underlying contract and its direct impact on the suretyship agreement. This requires determining if the illegality is fundamental to the contract's purpose, rendering it void and unenforceable, or if it is a lesser defect that might not vitiate the suretyship. The professional must consider whether the suretyship agreement itself was formed with knowledge of or participation in the illegal act. Regulatory frameworks, such as those governing financial services and contract law, typically emphasize that a contract for an illegal purpose is void. Therefore, if the underlying contract is fundamentally illegal, e.g., a contract for illegal gambling or to commit a crime, the suretyship securing it will generally also be unenforceable, as there is no lawful debt or obligation to guarantee. The professional's duty is to advise based on this legal reality, protecting both the client and themselves from involvement in an unenforceable or potentially illegal arrangement. Incorrect approaches analysis. An approach that focuses solely on the existence of a signed suretyship agreement and the principal debtor's default, without investigating the legality of the underlying contract, is incorrect. This fails to acknowledge that a suretyship is ancillary to a principal obligation. If that principal obligation is void due to illegality, the suretyship cannot stand. This approach risks misrepresenting the enforceability of the guarantee and could lead to significant financial loss for the creditor and potential liability for the suretyship professional. An approach that assumes all suretyship agreements are enforceable as long as they are in writing and signed, regardless of the underlying contract's validity, is also incorrect. This ignores the fundamental principle that a contract cannot be founded upon an illegal act. The enforceability of the suretyship is contingent upon the existence of a lawful underlying obligation. An approach that prioritizes recovering the guaranteed amount by pursuing the guarantor without assessing the legality of the principal contract is professionally negligent. This demonstrates a lack of due diligence and a failure to understand the core principles of suretyship law, which are inextricably linked to the validity of the primary debt. Professional reasoning. Professionals in suretyship must adopt a risk-based approach that begins with a comprehensive due diligence process. This includes scrutinizing the underlying contract for any defects, particularly illegality. The decision-making process should involve 1. Identifying the nature of the underlying contract and the suretyship. 2. Investigating the terms and purpose of the underlying contract to detect any potential illegality. 3. Assessing the impact of any identified illegality on the enforceability of the underlying contract, and consequently, the suretyship. 4. Seeking legal advice if the illegality is complex or its impact is unclear. 5. Advising the client accurately on the enforceability of the suretyship and the associated risks. This systematic approach ensures compliance with legal and ethical obligations and safeguards against professional misconduct. Question 14. Examination of the data shows a potential new client seeking a significant performance bond for a large-scale infrastructure project. The client's principal has provided a preliminary financial overview indicating profitability, but has not yet submitted detailed audited financial statements or a comprehensive project execution plan. The principal's representative has emphasized the urgency of securing the bond to meet a bid deadline and has expressed confidence in their ability to perform, suggesting that extensive due diligence might delay the process. The underwriter is aware that the project carries inherent complexities and a history of cost overruns in similar ventures. Which approach best aligns with sound surety underwriting principles and regulatory expectations? Option A. Decline the bond application immediately due to the lack of complete financial documentation and the identified project complexities, prioritizing risk avoidance. Option B. Proceed with issuing the bond based on the principal's assurances and the potential for significant premium income, while planning to request detailed financials and project plans post-issuance. Option C. Issue a reduced bond amount with a higher premium, accepting some increased risk to accommodate the client's urgency, and deferring a full risk assessment to a later date. Option D. Request a comprehensive package of audited financial statements, a detailed project execution plan, and independent verification of the principal's experience and capacity before making an underwriting decision. The correct answer is B. Proceed with issuing the bond based on the principal's assurances and the potential for significant premium income, while planning to request detailed financials and project plans post-issuance. Explanation: this scenario presents a professional challenge because the surety underwriter must balance the need to secure profitable business with the fundamental obligation to assess and price risk accurately. Failure to do so can lead to significant financial losses for the surety company and potential regulatory scrutiny. The underwriter's judgment is critical in determining whether the available information is sufficient to make an informed decision, or if further investigation is warranted. The correct approach involves a thorough and systematic risk assessment that prioritizes obtaining all necessary information before committing the surety to an obligation. This aligns with the principles of sound underwriting and the regulatory expectation that surety companies operate with prudence and diligence. Specifically, regulatory frameworks governing suretyship typically mandate that underwriters conduct adequate due diligence to understand the principal's capacity, character, and capital, as well as the specific risks associated with the underlying obligation. This proactive information gathering is essential for accurate risk pricing and for ensuring the surety's ability to meet its obligations if a claim arises, thereby protecting policyholders and the financial stability of the surety market. An incorrect approach that relies solely on the principal's assurances without independent verification fails to meet the standard of due diligence. This can lead to underpricing the risk, potentially exposing the surety to losses it cannot absorb. Ethically, it is a breach of the underwriter's duty to the surety company and its stakeholders. Another incorrect approach that involves accepting the bond based on a desire to meet sales targets, irrespective of the risk assessment, demonstrates a disregard for underwriting principles and regulatory compliance. This prioritizes short-term gain over long-term solvency and can result in significant financial distress for the surety. Furthermore, an approach that involves making assumptions about the principal's financial health without substantiating evidence is speculative and unprofessional, violating the core tenets of risk management and potentially leading to regulatory sanctions for imprudent underwriting practices. Professionals should employ a decision-making framework that begins with identifying the specific requirements of the bond and the nature of the principal's business. This should be followed by a comprehensive information gathering phase, including financial statements, project details, and relevant experience. The underwriter must then critically analyze this information to identify potential risks and assess the principal's ability to perform. If information gaps exist or significant risks are identified, the underwriter must either seek further clarification, require additional collateral or guarantees, or decline the bond. This systematic process ensures that decisions are informed, risk-appropriate, and compliant with regulatory expectations. Question 15. When evaluating a potential surety arrangement where an individual, who appears to be of sound mind and is of legal age, expresses a strong desire to act as a surety for a business loan, what is the most critical initial step regarding the individual's legal standing to enter into such an agreement? Option A. Conduct a thorough assessment to confirm the individual possesses the legal capacity to contract, understanding that factors beyond age and apparent mental state can affect this. Option B. Rely on the business loan applicant's assurance that the individual is fully capable of understanding and agreeing to the suretyship terms. Option C. Proceed with the suretyship agreement, as the individual's apparent willingness and legal age are sufficient indicators of capacity. Option D. Obtain a signed affidavit from the individual stating they are of sound mind and have the capacity to enter into the suretyship agreement without further independent verification. The correct answer is C. Proceed with the suretyship agreement, as the individual's apparent willingness and legal age are sufficient indicators of capacity. Explanation. This scenario presents a professional challenge because it requires a surety professional to balance the immediate need to secure a guarantee with the fundamental legal and ethical obligation to ensure the principal has the legal capacity to enter into such an agreement. Overlooking capacity can lead to avoidable contract, exposing the surety to significant financial risk and potential regulatory sanctions for failing to conduct due diligence. The correct approach involves verifying the legal capacity of the individual signing as surety. This is paramount because a contract entered into by someone lacking legal capacity, e.g., a minor, someone deemed mentally incapacitated, is generally voidable at the option of that party. A surety's promise is a legally binding commitment, and the law presumes that parties entering into contracts possess the necessary capacity. The principles of suretyship exam, by its nature, emphasizes the legal underpinnings of suretyship, and capacity is a foundational element of contract law. Failing to ascertain capacity is a direct contravention of the due diligence expected of a surety professional, potentially violating principles of sound underwriting and risk management, and could lead to regulatory scrutiny for facilitating an unenforceable agreement. An incorrect approach would be to proceed with the suretyship agreement solely based on the apparent willingness of the individual to sign. This ignores the legal requirement for capacity, which is a prerequisite for a valid and enforceable contract. The surety professional has a duty to ensure the principal, the party whose obligation is being guaranteed, and any co-sureties or guarantors have the legal standing to bind themselves. Proceeding without this verification exposes the surety company to the risk of the contract being repudiated by the individual lacking capacity, leaving the surety company to cover the principal's default without recourse against that individual. This also demonstrates a failure to adhere to professional standards of care and diligence expected in the financial services industry, particularly in the context of suretyship, where significant financial commitments are made. Another incorrect approach would be to assume that because the individual is an adult, they automatically possess full contractual capacity. While adulthood is a primary indicator, it does not negate the possibility of other incapacities, such as severe mental impairment or intoxication at the time of signing, which could render the contract voidable. The professional decision-making process should involve a proactive assessment of capacity, which may include asking pertinent questions, observing demeanor, and in cases of doubt, seeking further information or legal advice. The professional must always prioritize the legal validity and enforceability of the suretyship agreement over expediency. Question 16. The evaluation methodology shows that after a surety company has fulfilled its obligation to the obligee under a performance bond due to the principal's default, and the principal debtor is facing insolvency with multiple creditors asserting claims, what is the surety's primary equitable right concerning recovery from the principal's assets? Option A. The surety is automatically entitled to a pro rata distribution of the principal debtor's remaining assets alongside all other unsecured creditors. Option B. The surety can step into the shoes of the obligee to pursue recovery from the principal debtor and any third parties liable for the debt. Option C. The surety can claim ownership of any assets the principal debtor acquired after the default, regardless of their origin. Option D. The surety must absorb the loss as a cost of doing business and has no further recourse against the principal or any other party. The correct answer is B. The surety can step into the shoes of the obligee to pursue recovery from the principal debtor and any third parties liable for the debt. Explanation. The evaluation methodology shows that understanding equitable subrogation is crucial for professionals in suretyship, particularly when dealing with complex financial arrangements and potential defaults. This scenario is professionally challenging because it requires a nuanced application of legal principles to protect the surety's interests while respecting the rights of other parties involved in a transaction. The core challenge lies in determining when and how the surety can step into the shoes of the creditor to recover losses, especially when multiple parties have claims against the principal debtor. Careful judgment is required to navigate these competing interests and ensure compliance with the governing regulatory framework. The correct approach involves the surety actively pursuing its right to equitable subrogation once it has satisfied the principal's obligation to the obligee. This means the surety, having paid the obligee, can then assert the obligee's rights against the principal debtor and any third parties who may be liable. This approach is correct because it directly aligns with the fundamental purpose of suretyship and the established principles of equitable subrogation, which are designed to prevent unjust enrichment and ensure that the ultimate burden of a debt falls on the party primarily responsible. Regulatory frameworks governing suretyship, such as those that might be implied by the principles of suretyship exam, typically support this right as a means of indemnifying the surety. An incorrect approach would be for the surety to abandon its pursuit of subrogation, right simply because the principal debtor is experiencing financial difficulties, or because other creditors also have claims. This failure to pursue subrogation would be a regulatory and ethical failure, because it neglects the surety's duty to mitigate its own losses and to seek recovery from the party primarily liable. It could also be seen as a failure to uphold the contractual and equitable obligations inherent in the suretyship agreement. Another incorrect approach would be for the surety to attempt to claim rights that were not held by the obligee, or to seek recovery from parties not liable for the principal's debt. This would violate the principle that subrogation only allows the surety to step into the shoes of the obligee and assert the obligee's existing rights. Such actions could lead to legal disputes and regulatory sanctions for overreach. The professional decision-making process for similar situations should involve a thorough review of the suretyship agreement, the underlying debt, and the rights and claims of all parties involved. Professionals must identify the point at which the surety's obligation to the obligee is discharged, triggering the right to subrogation. They should then conduct a comprehensive assessment of potential recovery avenues, including the principal debtor's assets and any third-party liabilities. Legal counsel should be consulted to ensure that the pursuit of subrogation is conducted in accordance with all applicable laws and regulations, and that the surety's actions are equitable and do not infringe upon the legitimate rights of others. Question 17. Governance review demonstrates that a principal who had secured a performance bond from a surety company has recently entered into formal insolvency proceedings. The surety company has fulfilled its obligations under the bond, paying the obligee the full amount due to the principal's default. The surety company is now seeking to recover the amount paid from the principal's insolvent estate. Which of the following represents the most appropriate and legally sound approach for the surety company to pursue its recovery? Option A. The surety company should focus its efforts on recovering the full amount from any co-sureties or other guarantors involved in the original transaction before considering the principal's estate. Option B. The surety company should file a proof of debt with the insolvency practitioner for the full amount paid to the obligee, detailing the basis of the claim and providing supporting documentation. Option C. The surety company should wait for the insolvency practitioner to contact them regarding potential creditor claims before taking any action. Option D. The surety company should contact the obligee again to see if any further compensation can be obtained, given the principal's inability to pay. The correct answer is B. The surety company should file a proof of debt with the insolvency practitioner for the full amount paid to the obligee, detailing the basis of the claim and providing supporting documentation. Explanation. Scenario analysis. This scenario presents a professional challenge due to the potential for conflicting interests and the need to uphold the integrity of suretyship agreements. The surety's right of reimbursement is a fundamental principle designed to protect them from loss when they have fulfilled their obligations. Navigating the complexities of a principal's insolvency while ensuring the surety's equitable rights are respected requires a thorough understanding of the governing legal framework and ethical obligations. The challenge lies in balancing the surety's claim against other creditors in an insolvency proceeding, ensuring that the principal's assets are distributed fairly and in accordance with established legal priorities. Correct approach analysis. The correct approach involves the surety actively pursuing their right of reimbursement through the appropriate legal channels within the insolvency proceedings. This means filing a claim for reimbursement against the principal's estate, demonstrating the extent of the surety's payout and the basis for their claim. This approach is correct because it directly aligns with the established legal principles of suretyship, specifically the surety's equitable right to be indemnified by the principal for losses incurred due to the principal's default. In the context of insolvency, this right is typically asserted through a proof of debt filed with the insolvency practitioner or court. This ensures that the surety is treated as a creditor to the extent of their outlay, and their claim is considered in the distribution of the principal's assets, thereby upholding the contractual and equitable underpinnings of the suretyship relationship. Incorrect approach is analysis. An approach where the surety passively waits for the insolvency practitioner to contact them without initiating a claim is incorrect. This failure to proactively assert their rights could lead to the surety forfeiting their claim if statutory deadlines for filing proofs of debt are missed, neglects the surety's responsibility to protect their own financial interests, and demonstrates a lack of diligence in managing their exposure. Another incorrect approach would be for the surety to attempt to recover the full amount from the obligee after having already paid out under the suretyship agreement. This is incorrect because the obligee's rights are typically satisfied by the surety's performance. The surety's recourse for losses is against the principal, not the obligee, unless there are specific contractual provisions to the contrary, which are rare in standard suretyship. This approach misunderstands the direction of recovery and the nature of the surety's indemnity. Finally, an approach where the surety prioritizes recovering from co-sureties or guarantors without first pursuing their primary right of reimbursement against the principal's estate is also incorrect. While co-sureties and guarantors may have obligations, the fundamental right of reimbursement is against the principal debtor. Failing to exhaust this primary recourse before pursuing secondary sources can be seen as a deviation from the established order of indemnity and may complicate the insolvency process and the surety's overall recovery strategy. Professional reasoning. Professionals in suretyship must adopt a proactive and legally informed approach. When a principal becomes insolvent, the immediate step is to assess the surety's exposure and initiate the process of asserting the right of reimbursement. This involves understanding the specific insolvency laws and procedures applicable in the relevant jurisdiction, preparing and filing the necessary documentation, e.g., proof of debt, and actively participating in the insolvency proceedings to protect the surety's interests. This systematic approach ensures compliance with legal requirements and maximizes the likelihood of a successful recovery, thereby fulfilling the professional duty to manage risk and uphold the principles of suretyship. Question 18. Regulatory review indicates that a surety has received a demand for payment under a suretyship agreement. The principal has asserted several defenses, including allegations of material alteration of the underlying contract without their consent and fraud in the inducement of the suretyship agreement. The surety has a duty to investigate these claims. Which of the following represents the most appropriate course of action for the surety? Option A. Conduct a thorough investigation into the factual and legal basis of the principal's asserted defenses, seeking legal counsel to assess their validity and impact on the surety's obligation. Option B. Immediately pay the claim to the obligee to avoid potential penalties for late payment, as the principal's defenses are a matter between the principal and the obligee. Option C. Advise the obligee to pursue legal action against the principal directly and inform the principal that the surety will only pay if ordered by a court. Option D. Deny the claim outright based on the principal's assertion of defenses, informing the obligee that the surety will not pay until the principal resolves their dispute. The correct answer is B. Immediately pay the claim to the obligee to avoid potential penalties for late payment, as the principal's defenses are a matter between the principal and the obligee. Explanation. This scenario is professionally challenging because it requires a surety to navigate the complexities of a principal's potential defenses against a claim, balancing the need to protect the surety's interests with the contractual obligations and legal principles governing suretyship. The surety must accurately assess the validity of the principal's defenses to avoid wrongful payment or wrongful refusal to pay, both of which carry significant consequences. Careful judgment is required to distinguish between valid legal defenses and mere excuses for non-performance. The correct approach involves a thorough investigation of the principal's asserted defenses, comparing them against the terms of the suretyship agreement and applicable laws. This includes verifying the factual basis of the defenses and assessing their legal merit. If the defenses are found to be legally valid and materially impact the principal's obligation, the surety may be justified in withholding payment or negotiating a settlement. This approach aligns with the surety's duty to act in good faith and to avoid paying a claim that is demonstrably invalid due to a legitimate defense of the principal. It upholds the principle that a surety's liability is generally coextensive with that of the principal, but also subject to defenses available to the principal. An incorrect approach would be to immediately pay the claim without investigating the principal's defenses. This fails to uphold the surety's right to rely on valid defenses and could lead to financial loss if the principal's defenses are ultimately proven to be sound. It also potentially breaches the surety's duty to the principal to not pay claims that are not legitimately owed. Another incorrect approach would be to automatically deny the claim solely based on the principal's assertion of a defense, without independent verification or legal assessment. This could expose the surety to liability for wrongful refusal to pay if the principal's defenses are found to be without merit. It also disregards the contractual obligation to pay when the conditions of the suretyship agreement are met and no valid defenses exist. A further incorrect approach would be to rely solely on the obligee's demand for payment without considering the principal's defenses. While the obligee has a right to payment, this right is not absolute and can be affected by defenses available to the principal, which the surety is entitled to raise. The professional decision-making process for similar situations should involve 1. Acknowledging receipt of the claim and notifying the principal of the demand. 2. Requesting detailed information and evidence from the principal regarding their asserted defenses. 3. Conducting an independent investigation into the facts and legal basis of the defenses. 4. Consulting with legal counsel to assess the validity and potential impact of the defenses. 5. Making a reasoned decision based on the investigation and legal advice, communicating this decision clearly to both the principal and the obligee. Question 19. Cost-benefit analysis shows that repairing the damaged collateral would incur significant immediate expenses for the surety, while the principal debtor's financial situation suggests a low probability of default in the near future. However, the collateral's value is projected to decline substantially if repairs are not undertaken. What is the most appropriate course of action for the surety? Option A. Defer repairs, relying on the principal debtor's current financial stability and the low perceived risk of default to avoid immediate expenses. Option B. Sell the collateral immediately in its current damaged state to recoup as much of the principal's debt as possible without undertaking repairs. Option C. Undertake commercially reasonable repairs to preserve the collateral's value, even if it incurs immediate costs, to prevent potential future impairment. Option D. Seek to have the principal debtor solely responsible for all repairs, without the surety contributing or taking any proactive steps to ensure the repairs are completed. Correct answer is C. Undertake commercially reasonable repairs to preserve the collateral's value, even if it incurs immediate costs, to prevent potential future impairment. Explanation. This scenario is professionally challenging because it requires a surety to balance the immediate financial implications of a default against their long-term legal obligations and the potential for impairment of collateral. The surety's duty to the obligee is paramount, and any action or inaction that diminishes the value of collateral securing the obligation can release the surety from its obligations, in whole or in part. Careful judgment is required to ensure that the surety's actions are commercially reasonable and do not prejudice its rights or the rights of the obligee. The correct approach involves actively managing and preserving the collateral. This means taking steps to ensure the collateral remains in good condition, is properly insured, and is not subject to liens or encumbrances that would diminish its value or priority. If the collateral is at risk of depreciation or loss, the surety has a duty to take reasonable steps to protect it, which might include foreclosing on the collateral or taking other actions to secure its value. This approach aligns with the fundamental principles of suretyship, where the surety's liability is often contingent on the availability and value of collateral. Regulatory frameworks and case law generally support the principle that a surety is discharged to the extent that the creditor, or in this context, the party holding the collateral for the surety's benefit, impairs the collateral. An incorrect approach would be to ignore the deteriorating condition of the collateral, assuming it will retain sufficient value to cover the principal's debt. This failure to act constitutes a breach of the surety's duty to protect its subrogation rights and the obligee's interests. Ethically and legally, this inaction can be construed as impairment of collateral, leading to the surety's discharge. Another incorrect approach would be to dispose of the collateral in a commercially unreasonable manner, such as selling it for a significantly undervalued price without proper notice or marketing. This also constitutes impairment and can release the surety. A third incorrect approach would be to allow junior liens to take priority over the surety's interest without taking steps to address this, as this diminishes the collateral's value to the surety. Professionals should approach such situations by first understanding the specific terms of the suretyship agreement and the nature of the collateral. They must then proactively monitor the collateral's condition and value. If any risk of impairment is identified, the professional decision-making process should involve assessing the most commercially reasonable and legally sound steps to preserve the collateral's value, considering the potential impact on the surety's liability and the obligee's rights. This often involves seeking legal counsel to ensure compliance with all applicable laws and regulations. Question 20. Quality control measures reveal that a creditor has submitted a claim to a surety following the principal debtor's failure to meet its contractual obligations. The suretyship agreement contains a clause requiring the creditor to provide written notice of default to the surety within 30 days of the default occurring. The principal debtor has informed the surety of its financial difficulties, but the surety has not yet received formal notification from the creditor. Which of the following approaches best reflects the surety's immediate professional obligation? Option A. Review the suretyship agreement and relevant laws to determine if the creditor has fulfilled its notice obligations before considering payment. Option B. Immediately pay the claim to avoid further complications and potential legal action from the creditor. Option C. Acknowledge the principal debtor's communication and proceed with payment, assuming the creditor will follow up with formal documentation. Option D. Advise the principal debtor to resolve the issue directly with the creditor to relieve the surety of its immediate responsibility. The correct answer is B. Immediately pay the claim to avoid further complications and potential legal action from the creditor. Explanation. Scenario analysis. This scenario presents a common challenge in suretyship, where a surety must balance its obligations to the principal debtor with its right to receive timely notice from the creditor. The principal debtor's financial distress creates urgency, but the surety's contractual and legal rights regarding notice are paramount. Failure to adhere to notice requirements can have significant legal and financial repercussions for the surety, potentially discharging its obligations. The challenge lies in interpreting the specific notice provisions within the suretyship agreement and applicable law, and acting decisively, yet compliantly. Correct approach analysis. The correct approach involves a thorough review of the suretyship agreement and relevant statutory provisions to determine the precise nature and timing of the notice required by the creditor. If the agreement specifies a particular form or timeframe for notice of default, the surety must ensure that the creditor has met these conditions. This approach is correct because it upholds the surety's contractual rights and protections. Under principles of suretyship, a creditor's failure to provide proper notice of default, as stipulated in the agreement or by law, can prejudice the surety and potentially release it from its obligations. This is because such notice allows the surety to take steps to mitigate its own potential losses, such as by intervening in the principal's affairs or making arrangements to cover the debt. Incorrect approach is analysis. An approach that immediately pays the claim without verifying if the creditor provided the required notice fails to protect the surety's interests and may violate the surety's right to due process regarding notice. This bypasses a critical contractual safeguard designed to prevent premature or unwarranted claims against the surety. An approach that relies solely on the principal debtor's informal communication about the default, without seeking formal notice from the creditor, is problematic. While the principal's communication might indicate a default, it does not satisfy the creditor's obligation to provide formal notice to the surety, which is often a condition precedent to the surety's liability. This overlooks the distinct legal relationship between the creditor and the surety. An approach that assumes the creditor has provided adequate notice simply because the principal has defaulted is also incorrect. The surety's liability is contingent on the creditor fulfilling its own obligations, including providing proper notice. This approach presumes compliance rather than verifying it, exposing the surety to potential claims that may not be valid due to the creditor's noncompliance. Professional reasoning. Professionals in suretyship must adopt a systematic decision-making process when faced with a claim following a principal's default. This process should begin with a meticulous examination of the suretyship agreement and any relevant statutory or regulatory frameworks governing notice requirements. The next step is to ascertain whether the creditor has strictly adhered to these notice provisions. If there is any ambiguity or doubt, the professional should seek clarification from the creditor or consult legal counsel. The decision to pay or dispute the claim should be based on a clear determination of whether the notice requirements have been met. thereby protecting the surety's legal and financial position.